All right, so it's noon Eastern Standard Time, so we'll go ahead and get started with today's webinar, Developing Issues in Agriculture, Legal Issues Related to Ag Data. And for any of you who missed the part one of this series, there is a link under webinar links, and it's the link to economic value of ag data. So if you want to visit that, that was part one. All right. Okay, so we have the next upcoming webinar is actually going to be June 27th on solar leasing, and we have another one to be determined, but in August on the Vet Med Feed Directive, so look out for those. And I want to thank everyone for signing in today, and I'll also introduce myself. I am Ashley Ellickson with Department of Ag and Resource Economics at University of Maryland, and I'm here with Dr. Shannon Farrell from Oklahoma State, Department of Agricultural Economics. And I will also thank our sponsors today. They're listed there on the bottom of the slide. I won't name them all off. We do have quite a few. And just a reminder, and I'll say this at the end, there's also an evaluation under webinar links, and if you guys could fill that out and let us know what you think about today's webinar and give us ideas on what other webinars you might like to see in the future. So with that said, I will go ahead and hand it over to Shannon.
All right. Good afternoon / morning, everyone. Thank you all for signing up. I noticed that there's actually a few folks on the registration list that have actually seen this presentation before, and if that's true, I apologize. The jokes have not improved or been updated, so you know what you're getting into. This topic's really been fascinating for the past couple of years simply because we've seen such explosive growth in this topic, and every day it seems like there's a new news development taking place. As a matter of fact, just last week we saw the announcement that there is a takeover bid by Bayer to purchase Monsanto, who of course had purchased the Climate Corporation, which was one of the main operators in the ag data space. And so there's always something new to talk about here. But even given that, a lot of the concepts we're going to talk about today are topics that have been there since the dawn of intellectual property law. And so we're really trying to shoehorn a very new and innovative data technology into very old legal doctrine. So we'll talk about what it looks like right now and what some of those directions might look like in the future as that changes. Ashley already mentioned a lot of our sponsors. We just want to thank all of them for helping to get the word out about our presentation today. And I personally would like to thank several folks that have helped me in my understanding of these issues. First and foremost, Dr. Marvin Stone, who was a professor here in our Biosystems and Agricultural Engineering Department. Dr. Stone literally wrote the book on some of the data transfer protocols that are used in ag data transfers, and so we really wouldn't have much to talk about today if it wasn't for him. And we lost Dr. Stone tragically in the OSU homecoming accident in the fall of 2015, and so we really miss him. Ryan Jinlick did a lot to help me understand a lot of the intellectual property framework that we'll be presenting today. Terry Griffin, who actually did the predecessor webinar in this series, has helped me a lot to understand a lot of the mechanics of farm data transfers and those issues. Matt Steinert has helped me a lot seeing how this applies at the actual farm level because he's embraced a lot of these technologies and showed me how it's worked on his operation. Ryan Johnson and Kevin Thedford, both former students of mine, have really helped me understand how this works from the service provider and the equipment provider perspective. And then, of course, Todd Jansen has done a lot of work on this front in helping farmers and ranchers understand these topics and integrate them into their production arrangements. So I really want to thank everyone that kind of helped inform our understanding of these issues because we wouldn't be here talking about them today without them. Now, we talked about the fact that things are changing in agriculture, and the fact of change is really nothing new. There's been change in agriculture as long as we've had agriculture. So what's really different, I suppose, is the pace of that change. I mean, we've seen legal issues faced by our producers in the past 2 or 3 years they wouldn't have even thought about prior to that point. So that pace of change is what's really driving the need for a lot of the legal education that we're having and why we're having this webinar today. And what's occasioned a lot of that change is the fact that we're finally getting close to a goal that I think lots of us have had for some time, and that's mobile, completely connected, analytic agriculture. And what I mean by that is we can access data about our farm from basically anywhere. We have now the capability of making our planter, our fertilizer applicator, our combine, our tractor, all talk to each other, and we can actually use the fact of that mobile and connected agriculture to give us the opportunity to make management decisions that we never really could have made before. We're never going to get all the risk out of agriculture, but we can know more than we've ever known before and have access to that information in more ways and have more analytical power put behind helping us form management decisions. But in order to have access to that analytical power, to really get the benefit of, insights from databases that connect maybe tens of thousands, hundreds of thousands, perhaps someday even millions of farms, we've got to share that data with somebody. And it's at that point that lots of producers start to get a little bit anxious because they've never really known this information themselves, much less share that potentially with lots of other people, and that's naturally a grounds for some concern. There's some privacy issues in there, obviously, but additionally, they're kind of wondering, if I share my data with someone else, who gets the economic value of that sharing? Am I getting my fair share of the value that's created from sharing that data? So there are lots of questions there, and that's led lots of people to ask the question, who owns my data anyway? And we may discuss in this seminar the fact that the question of who owns it may not be the question to ask, but it is a question on lots of people's minds. So let's talk about how we actually own data in the first place anyway. And for those of you that are lawyers, you've seen this in your first year property class in law school, but if you're not, you may not have ever sat down and really thought about what it means to own something. In law school, when we talk about ownership, your professor will always bring up the bundle of sticks, that property ownership consists of this bundle of rights that can be unbundled as well. And we usually regard property ownership as a person's ability to have and enforce 6 primary rights with respect to any item, whether it's tangible or intangible, whether it's a piece of land or whether it's a copyright concept. But we talk about the right to possess it, meaning do you have the right to engage it on your own? That's something that's pretty easy to see with physical property like land or equipment. You have the right to be on it, using it. But with digital property, that loses a little bit of meaning, because what does it really mean to possess something that's intangible? But that's not a deal breaker. We come to the right to use, which means the right to interact with it or perhaps alter it. And again, when we're talking about tangible property, that's pretty straightforward. When we're talking about digital property, that means do we have the right to manipulate it, to engage with it, or to change it in some way. The right to enjoy means the right to profit from. When we talk about life, liberty, and the pursuit of happiness, what we were really talking about is life, liberty, and the right to profit from what you do. So when we talk about the right to enjoy property, we mean who has the right to profit from the use of the property. Next comes the right to exclude others from. And again, easy concept with physical property, more difficult with intangible property because, and Terry Griffin would give you this analogy as well, let's talk about your favorite movie. And if you enjoy the same movie I do, does that mean that my value in that movie, the intellectual property that I might have owned if I purchased a copy of that movie, was that diminished by the fact that you bought a copy of the same movie and you enjoyed it also? And the answer is really maybe not. So the right to exclude others from intellectual property, like data, has a very different meaning. And as a matter of fact, it might be, to extend our analogy a bit further, that because 2 people have access to the data or the intellectual property, they might actually increase the value to each other if they could share information and insights about that data with each other. Terry and I both like Star Wars. If he gets a copy and I get a copy, we watch it, we talk about it, we derive value from the exchange of information about what we both thought of Star Wars. Well, we've actually increased value rather than decreased it. The right to transfer simply means do we have the right to separate our ownership from ourselves and give it to someone else? And then the right to consume or destroy is again a concept that's very difficult to get your head around when you're talking about intellectual property, especially data. Terry has a copy of Star Wars. I have a copy of Star Wars. I delete my copy because I just need space on my computer. That has no impact on Terry's ownership whatsoever. And so just because I've destroyed that copy doesn't mean that all copies are destroyed. Matter of fact, a little bit later we'll talk about the fact that data destruction is a really tricky concept. So we've said all this simply to bring to mind the fact that we can have ownership of intellectual property. That's without a doubt. We've been thinking and knowing that for years. But the thing is, how those rights are enforced and how they're used is very different with intangible property like data, and so we have to think differently about how we approach that when we're talking about intellectual property. So instead of talking about who owns it, which could be a very academic, scholarly debate, maybe what we should say is, when we're talking about agricultural data, what are the rights and responsibilities of the party with respect to that data? Now, to talk about the legal rights and obligations that we have with respect to information, we have to look very quickly at an intellectual property framework. Mostly, our intellectual property comes from federal law. Trademark, patent, and copyright are all functions of federal law because the Constitution specifically says Congress has the power to enact statutes with respect to those kinds of intellectual property. Trade secret is different. Trade secret is actually a function of the old common law that goes back centuries, but as a common law animal, it exists pretty much as a function of state law. So state statutes and state cases will govern trade secret. So what we have to do is really figure out which of these areas fits agricultural data. And we'll have to do this a little bit by the process of elimination. So here we go. First off, trademark is a lousy fit for agricultural data because trademark was never meant to protect anything that looks like data. Trademark is meant to protect symbols or identifiers for a product. The shape of a Coca-Cola bottle, white script lettering with Coca-Cola on a red background, the golden arches of McDonald's. Those are all things that are trademarks. And so trademark doesn't really have anything to do with information. Trademark is meant to deal with identifiers. So let's move past trademark. Now let's talk about patent. Now patent initially seems to make a little bit more intuitive sense because we've seen inventions patented, we've seen processes patented, but when we're talking about a patent, we're trying to protect a process or a device that's useful, novel, and non-obvious. Useful means it's capable of doing something that we find valuable in society. Novel means it's different enough from existing knowledge in that area that it's distinguishable as a separate idea. And non-obvious means it's something that wouldn't just be apparent to anyone. You'd actually have to do some work, do some development, do some research to come up with that concept. And so in the realm of ag data, when we're talking about this, your data display in your tractor, that's a device that's patentable, okay? The information going through it might be a different story, but the device and the processes that the device uses to display information, that is something that's patentable. Patent doesn't work for pure data, though, because, again, the definition simply says that we're talking about a process, a machine, manufacturing, composition, improvement. All of that is what we're talking about with a patent. So information in and of itself isn't patentable. So then that leads us to copyright. Now copyright should start to feel to you a little bit more intuitive when we're talking about data because you probably own a book, or you've got a digital download of some music, or you've got software on your computer. Those are all things that seem to be kind of related to information, and those things are all copyrightable. And that's true. But we can't copyright information in and of itself. What we're talking about with copyright is original works of authorship fixed in a tangible medium of expression. And that sounds nice and lawyerly. What does that mean? When we talk about original works of authorship, what we're saying is there has to be an element of human creativity involved. We didn't just take raw data, we didn't just take raw information. Somebody intervened with that information and created it or arranged it in a way that's different from its natural state. So there has to be some creativity. And then when we see fixed in a tangible medium of expression, we simply mean that information is recordable in some way that we can retrieve it. It's not fleeting, it's not ephemeral. It means we can actually lock that information down and pull it back when we want to. And if you look at the list of things that the copyright statute says are copyrightable, all of this kind of makes more sense. You look at this list, you say, okay, those are all things that involve some authorship, some creativity, some sort of human engagement there. And the Supreme Court has very specifically said that we're talking about information that's been modified in some way. So we can't just talk about raw facts as being copyrightable. And where this came down was in Feist Publications versus Rural Telephone Service. In that case, the Supreme Court said, look, you can't copyright the white pages because there's no creativity involved. That's just raw, pure information there. There's no other way to arrange the phone book except by number instead of by name, and if you do that, you've rendered it non-functional. So you can't have any creativity with pure data. But if you engage with that information and create a layout for it, and maybe you add some pictures and some editorial comments, now you've got something that's creative and can be copyrighted, like, for example, an encyclopedia. Kids, if you don't know what an encyclopedia is, that's what your parents told you to look up stuff in before there was the internet, okay? So you can copyright the encyclopedia because there's an element of creativity to it, but you can't copyright the white pages. No creativity, it's just pure data. Now, when you hear that, you think to yourself, well, if I can't copyright data, what's left? Because my farm data is just that. It's farm data. It's information that my combine generates about how fast it's going, how much grain it's hauling, what the moisture content of that grain is, where it was according to the global positioning system. It's just information. There's not really creativity added to it. Can I protect that sort of thing? And so that leads us to trade secret, because trade secret might just work. For something to be a trade secret, the Uniform Trade Secret Act, which is state law, but it's been almost universally adopted by all the states. The last time we did our research, all but 2 states had adopted it, and they actually had legislation pending to adopt it. But what the Uniform Trade Secret the Uniform Trade Secret Act says, is that information can be a trade secret. So it's okay if it's just raw data. That's fine. The Trade Secret Act can encompass that. It can protect information that, number one, derives independent economic value from not being generally known. And what we mean by that is that information has economic value because it's a secret. Not just that it has economic value, that's not enough. It has to have economic value because it's not known. In other words, if everyone knew that information, it would lose its value. But because it's a secret, it has more economic value. So that's step number one. It's got to have value from being a secret. Number two, the person that holds the information, or the people that agree to hold the information between themselves, have to take efforts to make sure it stays a secret. And the classic example of that is the formula for Coke. The formula for Coke, honestly, could be patented if someone wanted to do it, but no one ever does, because that would mean they would have to disclose the information as part of the patent filing. So the formula for Coke is written down and kept only in one place. That's in a safe deposit box in Atlanta, Georgia, in a bank downtown. Only 2 people can know the formula at one point in time, and their identities are not disclosed to the public. Those 2 people cannot travel on an airplane at the same time, and the only way that the formula can be examined or revealed to anyone else is by a unanimous directive from the board of directors of the Coca-Cola Corporation. That's a pretty aggressive program for trying to keep something a secret, okay? Now, you don't have to go that far. What the law says generally is that if you want to maintain something as a trade secret, you basically have to take reasonable steps, quote-unquote reasonable, whatever anyone else would regard as being reasonable, as in 12 people in the jury say is reasonable, to ensure the information doesn't become generally known. And one corollary to that is that if I'm sharing my information with someone else, I have to go to even more efforts to make sure my information isn't disclosed. So what the case law and the restatements of the law would say is that the more people I disclose information to, the more strict I have to be about what those folks do to make sure that information isn't disclosed to anyone else. That becomes very relevant for us in agriculture if our tractors are constantly discharging information to a service provider somewhere, whether that's the equipment manufacturer or whether that's a crop consultant or whatever the case might be. If I'm constantly disclosing information, then I better be having a pretty good legal framework around the person to whom I'm disclosing it to make sure that information stays a secret. So how do you do that? Well, if it wasn't for the wireless transmittal of information, we'd say maintain the physical security of that information. Keep it locked away. Put it in a vault that only you know the combination to and only get it out when you absolutely have to. Now, that's great if we're talking about physical information, but if we're talking about digital information, that's not really practical. Since this information is being retained on a computer, Okay, we could talk about maintaining computer security, and of course have a password for the computer that's something other than password or 1234 or anything like that. You can even use some biometric imprint security. But that only secures the computer that you're directly interfacing with. If you're disclosing this information to someone else, you now also have to worry about the security of their system and how secure they're keeping it. So that's one point. We could label the information confidential. That's relatively easy to do with physical information, although there actually have been studies that show labeling information as confidential actually makes it less confidential because it makes it more of a temptation for people to access it. And it's really difficult for us to stamp digital data as confidential. That's one thing. Now, on the other hand, if we're transmitting our data by cellular modem, cellular data is actually fairly difficult to hack, given the security protocols that are used to encrypt it on one end and decrypt it on the other end. Even the NSA and the FBI have had to ask for help from Apple, as you've probably heard in the news, for decrypting stuff that the owner doesn't want decrypted. So we actually have a fairly high degree of data security relative to other means of transmitting information out there. Anytime you hire or fire someone, you have to verse them in how you keep this data secure. And if someone gets terminated or leaves or retires or resigns, you need to make sure that all the passwords are changed, that all the physical means of accessing the data are altered as well, so that someone can't come back and then access data to which they should no longer have access. Now, all these things are great when we're talking about physical data, but when we're talking about digital data, it's just really tough, and these things start to lose a lot of value. So what we may have to do then is talk about the relationship that we have with the person that we're transmitting this data to, and agreeing between us what can this data be used for, what measures will we take to make sure that it's not disclosed to other parties, and what are the consequences if it is. And regardless, by the way, of whether our data fits as a trade secret or not, because there actually are some counter arguments that say that ag data wouldn't be considered a trade secret. Regardless of that, if we have a legally binding non-disclosure agreement with the other party, we can agree that we're going to keep that information a secret. So what needs to be in a non-disclosure agreement? How does all that work? To answer those questions and many more, I will turn it back over to Ashley.
All right, thank you, Shannon. And just a reminder, I didn't mention this at the beginning, if you have any questions, there's a box there, a Q&A box if you want to go ahead and type any questions in, but we'll take them also when I finish my portion here. So, okay, jumping back in, the non-disclosure agreements. What are the essential provisions? How can they be used? All these questions that come along if you're, again, maybe not a lawyer or you don't look at these frequently. You want to make sure to execute a non-disclosure agreement before any disclosures are made. So before the employee starts working and has any access to anything that might have data on it from the farm, you want to make sure this non-disclosure agreement is signed and agreed upon. You also want to define who is doing the disclosing and who is doing the receiving. So typically, if the discloser is going to be the farmer or possibly the manager, and then the receiving person might be your agriculture technology provider or possibly the employee, whoever it is, you want to make sure that those people are defined within the non-disclosure agreement. You're also going to want to define exactly what trade secrets are going into this agreement. So one farm might have a different definition of this than maybe another farm. And you're going to want to make sure that that is explicitly defined in the agreement. Mark all confidential information, list trade secret categories, and then again specifically identify the information. I'm not sure if it's on the next slide. Okay, it is. So on the opposite side of the coin, you're going to also want to exclude what is not protected as a secret. You're going to want to make sure that is well known. And typically these things are going to be types of information that are publicly available. So possibly the zoning maps to the land that you could probably go get if you go look at a title. And those are pretty much publicly available at this point, even online. Discovered prior to disclosure. So if an employee happens to see data before the NDA is actually signed, this could be data or information that is discovered prior to disclosure and would be excluded from this contract. Legitimately obtained by other means, I'll let you use your imaginations there, and disclosed with permission of disclosing party. So here, maybe the farmer said, I will disclose this, it's not going to be considered farm data under this agreement. So whether that's the type of seed that you're using or whatever it might be, but you're going to want to make sure that everything that's not going to be considered a secret within disclosure is actually excluded. Establish the duty to keep information secret. So this might be the most important part of an NDA. This creates that agreement between the parties that this information that we're discussing in this non-disclosure agreement is actually going to be kept secret, and we are creating those duties between the parties. Information to be held confidentially, measures required to ensure secrecy, which Shannon kind of touched on this before, so whether that's how to access, if there's a code to access information on computers, or if there's a code to access the information from tractors or equipment, you're going to want to make sure that that's understood. And explicit prohibition of disclosure. Again, this might seem intuitive, but it's going to want to be stated in the non-disclosure agreement that this agreement is actually prohibiting any disclosure of any of the data or any of the secret that is being defined within the non-disclosure agreement. You're going to want to make sure that between the farmer and the attorney that you're specifying the allowed uses and prohibited uses of the data being disclosed. And something, let me see, it's not here, but something to consider is you want to also make sure there's a balancing act here. You want to make sure that it's not prohibiting the incentives that the farmer has to be using the agriculture provider, but you also want to make sure that those uses are also protected in a way. So it's kind of a balancing act. You don't want to completely shut all the uses off so you can continue those incentives, but you want to make sure that you're stating exactly what those uses are and what the prohibited uses are. Set period of enforceability. So this is usually defined by an event rather than time. Instead of saying this contract is going to go for the next 10 years or at the end of the employee's services here, it's going to be defined in some manner, something like when the farmer decides to disclose the information, or basically an event rather than an actual time specific date. And then other potential terms in an NDA agreement, data destruction requirements, and Shannon again touched on this earlier, and Terry Griffin goes into great detail with this about the idea that data is kind of impossible to completely erase. The types of things that you as a farmer can consider as far as erasing or deleting could be if there's a backup drive, you want to ensure that the data is somehow at the end of this agreement destructed on that drive. Or if there's any hard copies of the data, you want to make sure that maybe those are deleted or destructed at that time. But in theory, data is very difficult to delete entirely. You're going to also want to consider maybe injunctive relief or an indemnity clause. Oh, so back to injunctive relief. If you don't agree to this in the non-disclosure agreement, it is actually going to be a court procedure where you seek injunctive relief. So what do we know about court procedures? Even if you're not an attorney or in the legal field, it takes time. It takes money. So if you agree to this ahead of time, this can save you time and money for both parties. The indemnity clause, possibly an integration clause, which basically says that everything that was agreed upon between these parties is entirely enclosed within this contract. There may have been some notes taken on a separate sheet of paper at some point. That's not going to be considered part of this contract because of the integration clause. And again, attorney's fees, which is very common throughout contracts in the United States, and then possibly an alternative dispute resolution clause, which basically states that before going to court, we'd like to pursue either mediation or some other form of dispute resolution. Again, to kind of save time and money. And again, this is something, if you're going to enter into one of these, you're going to want to talk to your attorney about. So, disclosure under legal process. So disclosure is prohibited under the legal process. So if you're going into court or into arbitration, unless subpoenaed or otherwise compelled by the legal process. So unless a court subpoenas you for that data, you don't have to disclose the data or the information. And give the disclosing party as much notice as possible to either contest the process or see what other options the party has to prevent it. The receiving party must use best efforts to cooperate with the disclosing party, and receiving party may disclose only information which, in the written opinion of its legal counsel, it is required to disclose. So that's going to be a case-by-case and situation-by-situation type of, I guess, situation. It's going to be very unique to each person's issue. So this isn't all-encompassing. Limitations of NDA. So like most contracts, there's going to be some sort of limitations. Disclosing party fails to use reasonable efforts to maintain its secrecy. So if there were, again, reasonable quote-unquote efforts that were agreed upon, or that a jury was going to find reasonable and the disclosing party failed to do these things, then again, it's not going to protect the disclosing party. Information is generally known or readily ascertainable. And again, this is something like I talked about before. If you can find it some other way besides going through the farmer or the landowner, then it's going to be considered readily ascertainable by courts. And the case that's coming to mind is along the lines of where a company actually had a list of clients, and at one point the court found that this list of clients was readily ascertainable because they could find this list of clients elsewhere. It was open and public information. So again, unless it's not readily ascertainable, you're going to be protected there. Information is learned through independent discovery, and then information is learned through reverse engineering. And again, you can't unring a bell. So once something is disclosed, the data is going to be out there, and then you're going to have to deal with the issues moving forward. Another question we frequently get, which I'll go ahead and address, is data ownership between landowner and tenant. So all across the United States, you have these relationships where the landowner doesn't do the farming. They just happen to own the land, and there's an agreement with a farmer who is actually farming their land. So what happens with data ownership between these two parties? Well, I will go ahead and go over just a brief overview of this. I got to give credit to Todd Jansen. He's the one who kind of pioneered this way of thinking, and including some provisions in the tenant-landlord relationship. So no matter who is going to be the owner at the end, who is going to basically, the data is going to stay with, it's either going to be the farmer, and they're going to argue, again, that they did the work on the farm. It's their equipment that's doing the work. They should own the data. Alternatively, the landowner is going to say, it's my land. The data is taken from the land that you're farming. I should own the data. No matter who the parties are, these are three provisions that are thought that are going to be very helpful moving forward. So you're going to have to start with who's going to be the owner, and then you're going to want to define farm data. What's going to be included as farm data? And it may be, particular within your region, particular within the equipment that's being used. You're just going to want to make sure the definition of farm data is there. And everything you want farm data to include is going to be stated in the lease. And then the provision establishing who owns the farm data. So again, the farmer who's farming, the tenant is going to have his or her arguments as to why she should own it or not own it. Same thing with the landowner. So it doesn't matter at the end of the day who's going to own it, just it needs to be decided upon and then stated within the lease. And then again, the provision defining what happens to farm data at the end of the lease. So even if throughout the the land lease relationship. Maybe it goes 20 years in some parts of the country. Over here in Maryland or Delaware, you see them for a year. It doesn't matter, but at the end, if it stays with the farmer throughout that relationship, maybe at the end of the relationship, it transfers back to the landowner because maybe he needs the data for the next farmer who's going to come farm his land. So it doesn't matter if that's the situation or if maybe the landowner is always going to have the ownership. You're going to want to define who is going to own it at the end of that lease. So again, I want to thank Todd Jansen for those provisions, but those are some things to consider if you have a landowner and tenant relationship when it comes to farm data. And I'll go ahead and hand it back over to Shannon to talk to us a little bit about future policy directions.
And first off, I'm glad we've managed our time well. Ashley and I talked about this in advance, and we wanted to make sure we kept things fairly short so we could ask questions. So if you haven't already asked a question, please make sure you do that over in the Q&A box. We've got some good ones already queuing up over there. We've talked about the fact that the current intellectual property law framework really doesn't fit ag data very well. And we could see changes for that. For example, we've got statutes like HIPAA that govern how we go about transmitting and disclosing information about someone's personal health. We have the Fair Credit Reporting Act that deals with how we talk about and disclose financial data. Could we have something like that for ag data? And the answer is, yeah, we could. It would take some work for us to define what ag data is, and would also, by the way, editorial comment, take Congress being able to pass a law, and we haven't really been doing too well at that for the past few years. But that's something that could happen out there. Could we have statutory rules governing data storage and disclosure? In other words, if we have email traffic, that's protected by a federal statute. If we talk about voicemails and telephone traffic, that's protected by a statute. But when we're talking about data exchange and data storage, we really don't have good statutory rules that govern those relationships. I think that's probably more likely to happen than rules about data ownership on the farm side, but it's something that we don't have, and I think we're going to have over time. One thing that we've talked about today is the use of non-disclosure agreements. And non-disclosure agreements work well when we're negotiating between a couple of parties about who should be able to disclose what and how they should be able to use information. That doesn't work really well when we're talking about an individual consumer negotiating with a multinational corporation. They probably don't want to negotiate a million different non-disclosure agreements. So what they probably do is have a click-through agreement, like you've got for your iTunes user agreement. You want to use our service? Click here that you accept the terms and conditions and move on with life. There's been some discord amongst the federal circuit courts about whether those sorts of agreements called end-user license agreements, specifically click-through end-user license agreements, are enforceable, because some people would call them adhesion contracts, meaning there's a complete asymmetry of negotiating power, and there really is no opportunity for one end of that contract to negotiate with the other. So that's something I think the courts are going to have to resolve, and Congress may have to get involved with that one as well. And then this actually goes to one of the questions that was in the question box. How do the legal doctrines that we've been talking about today apply when we're talking about aggregated data versus data in and of itself? And perhaps the irony is that as we become part of an aggregated data set, if we take data about our individual farm, that data is very individually identifiable to us, and arguably there might be some privacy concerns there. But as our data is aggregated with a set of 100, 1,000, 10,000, 100,000 other farms, our data kind of gets lost in the sea, so to speak. And that's not to say that data is not valuable. Quite the contrary. There might be tremendous value in us looking at those aggregated data sets and trying to draw trends and pattern analysis from it. But it becomes much more difficult for us to distinguish my farm's data and your farm's data and really tie those back to us. So while we might have pretty strong rights, or relatively strong, I should say, in an individual context, those rights become somewhat diminished when we're part of an aggregated data set. But the trade-off is the aggregated data set might provide us more protections just based on the anonymity of that data set. Now, some of the data theorists would argue with me to say there is no such thing as anonymity in data, and that I understand. But I'll give you an example. In the Census of Agriculture, if there is one ostrich ranch in a county, the Census of Agriculture will not report data on ostrich ranches in that county, because if they disclose that data, they've revealed basically the information about one party's operation. But if there are 100 ostrich ranches in a county, they'll feel more comfortable disclosing that information because it won't be as easy for someone to interpolate what one individual operation looks like. So there's another example of where anonymity in the data actually comes from its aggregation. I'll tell you right now that there are probably very limited protections for someone whose data is included in an aggregated data set, provided, of course, that there's not individual identifier information tied to that, simply because there's presumably more anonymity there. Furthermore, there's probably not a lot we can do to protect our rights in an aggregated data set, unless, of course, we've negotiated that in our disclosure agreement, because that aggregated data set is probably something different than the raw data that we've provided. I might be able to claim, for example, a trade secret interest in data that I provide to a service provider. But if that service provider takes my data and the data from 1,000 other farms, pulls it together, does some trend analysis, some benchmarking, they've created a new thing. I didn't have a hand in that other than contributing some data. So it's quite likely that they would have the intellectual property rights in the new thing, the aggregated data set that's been created, and I wouldn't. And that's been a topic of some concern for farmers and ranchers, because they say, hey, is it possible that I could disclose my data to someone and they wouldn't have to give it back to me? Now, the answer is they would have to give you back the data that you gave them, most likely, but they might not have to give you something that is a product of the data that you provided to them. So that's a question that's going to get more attention as time goes on there as well. That concludes the formal part of our presentation here, and Ashley's information and mine as well is presented for you here. But I think now it's time for us to go over to the question box and take on some of the Q&A that we have over there. First off, Terry Griffin from Manhattan, Kansas, asks if we can shoot down drones, which is nothing to do with really what we're talking about, but it's a question we get every presentation anyway, and the answer is no, you can't shoot down drones. And I'll be speaking on that very point later this week in Lubbock. So thank you for your question, Terry. We've talked a little bit about aggregated data there. Have there been any cases regarding the proper handling and disclosure of ag data? That's a very good question. I haven't seen any reported cases about data disclosure yet. What we've seen, we've kind of had to draw from analogy from case law and other areas. But I suspect that's not going to be the case for long. I bet we do see those issues arise in some litigation before too awful long. And I think we're going to see it along those lines of, what exactly are those privacy rights, or are there privacy rights in agricultural data? What are the consequences if someone uses data for a purpose other than what we agreed to in the disclosure agreement? Obviously, if someone breaks a disclosure agreement, they're in breach of contract, but then the next question the court is going to ask is, okay, what was the economic consequence of that breach? If there was no economic consequence, should there be any form of damages rendered to the producer? So that's something that we'll have to see. And Ashley, by the way, I'm just going to town on these questions. Anytime you'd like to take one, let me know. Go ahead.
Unfortunately, Shannon, I can't open them. I can't see the questions, so if there's one you want to hand off to me, that's fine too.
Okay,
or
excellent.
if you want to read them.
No problem at all. Let's see here. Paul has a question. Do you have model provisions for a lease to protect how data is owned? Sort of, kind of, yes, maybe. And I will refer to our good friend Todd Jansen at Jansen. Now I'm going to forget Todd's website address. It's aglaw.us, I believe. Todd, if you're on there, give us a comment. Let us know if we got that right. I think it actually is in the acknowledgments there. But Todd has some information about that on his website. We actually have an article forthcoming in the Drake Journal of Agricultural Law talking about those points, and those are actually points we developed with the help of Todd there. But if you want to reach out and contact us, we're happy to kind of help you get some of that information if you'd like to include that in your agricultural lease. Jeff asks, if I own the land and sell the farm to someone else, are the new owners entitled to the data if they ask for it? Can I keep any of the data? Ashley, that's in your wheelhouse. Go ahead.
Well, I would tend to think that this would be a negotiating tool. I think that you have the right to either keep that data, or if you would, feel giving, that you could actually negotiate that and hand that over to them. It's up to the parties to agree upon. Shannon, do you have something to add or something different?
Well, I would just exactly echo what Ashley said. It's really going to be a function of the private negotiation between the buyer and the seller, because you could argue that there's really no requirement that if I'm selling you the farm, that I'm required to turn over whatever data I have about the farm. Unless that's specifically a part of the sales contract, there's really nothing that requires me to do that. Now, of course, you can get into the latent defect doctrine and say, hey, if you knew something was wrong with the farm, you had an obligation to tell me. And that's true, but that usually refers to if there's some sort of hidden danger on the land that I wouldn't have known if I would have inspected it. I don't know if the court would say, well, the fact that you've got a nitrogen deficiency over in this part of the field, or that your pH value is really high over there, is that really going to be considered a latent defect? And I think the courts would say probably not. Now, having said all that, as I'm moving forward, if I'm a farmer or rancher, that data is a big issue to me, because it's only going to become more important as time goes on. And as Terry mentioned in his webinar a few weeks ago now, that may actually be a driver of farmland values in the future, how good your data set is. If Farm A and Farm B are basically equal, but Farm A has a much more robust data set that I can use to make better production decisions, I might pay more for land A. Rachel asked, if I access and use your data with your permission, how might damages be calculated? Do I have to actively use the data against you in some way, or is it bad enough that I got hold of it and started analyzing it without your approval? Fantastic question, and darn it, we should have had Terry on here with the microphone, because that's actually a question Terry's been asking a lot in his research. I mean, really, what's the value of data? And there's two potential answers there. The lawyer answer says whatever 12 people in a jury says the value of that data should be. The economist answer is, how does that influence your ability to make decisions? If I would have made decision A with the data, but I didn't have it, so I made decision B, what was the change in my profitability between decision A and B? So that's arguably the value of the data, which, I mean, that's well and good, but if we're trying to figure out what's the value of that data because it's been inappropriately disclosed, now we have to ask ourselves, from a legal perspective, what damage did you sustain because someone knew that data and you didn't want them to? If I'm a celebrity and someone says something bad about me, I might not like it, but did I lose a movie role for that being disclosed? Really, there's a difference between a libel or slander situation where we basically have information disclosed that was false or that shouldn't have been disclosed, versus did we sustain economic damage from that information being disclosed? The example that Terry and I talk about a lot in our presentations is getting access to farmland. Do I care if someone got all of my farm data, put it on the internet for everyone to see? Economically, does that really make any difference to me? And the only scenario we've really been able to come up with, and we've tried to think as evilly as we can, is what would happen if another tenant looked at our data and said, well, hey, I could do a much better job of farming than Farrell is doing with that piece of property. So he goes to my landlord and says, hey, you lease this land to me for more money, I'll get you a greater return to your investment than Farrell is because he's underperforming as your manager. So when we're talking about this in both the legal and the economic perspective, to get damages for misuse or acquisition of data, you really have to say what was the economic consequence, and that's really going to be tough for us to find, and it's going to take probably a few cases for us to even figure out how the courts would put that framework together. So that's a very good question. We were talking about data disclosures, and Scott Yeager mentioned the FOIA information release from EPA, which is interesting to talk about in this context. And that wasn't really I hate to say it, it's not really a data breach if someone willingly discloses it. And what EPA did was basically disclose a lot of information that really they weren't required to disclose, but that was pretty intentional on their part. So FOIA is a whole other realm to explore here when we're talking about basically willing disclosures of information. That's a really good point. Lyron asks, how relevant are data privacy issues from other internet industries to agriculture? For example, Uber using rider data to optimize routing, Facebook using data to optimize ads. Those are very good and very relevant, I think, analogies to draw to ag data. And again, I'm going back to Terry. Next time we do this, actually, we're just going to have to all three do it together at the same time, I think, because that loops back to what Terry was talking about in his presentation about the secondary use of data. And what do we mean by that? Terry has a great analogy that he uses with respect to Amazon. If you go onto Amazon and you're looking for a textbook that deals with ag data, you might find a textbook on ag data and get what you wanted and enjoy that transaction. But what Amazon is doing is looking at everything that you looked at, everything that you bought, everything that your friends bought, and then says, hey, if you like this book about ag data, maybe you'd also like this book about intellectual property. And so if they get you to buy a book on intellectual property just because you were looking for a book on ag data, you might have been made better off because, hey, now you got this other book that you didn't even know you wanted, and Amazon's way better off because they now sold you a book that you didn't even know you wanted. So that secondary use of data can have tremendous value to the data aggregator. And hopefully they share that value with you. So that's an important analogy to draw there and say, hey, if we're going to collect this data and look at patterns, for example, if John Deere is collecting information from 10,000 tractors and noticing these use patterns so that then in their next generation of tractors, they've designed a tractor that's more reliable or more efficient specifically to the uses that farmers are making of them, arguably that's made farmers better off, and it's probably going to make John Deere better off if they're selling more tractors. If ag input companies notice patterns about how certain types of seed varieties respond to these combinations of inputs, that enables farmers to make better management decisions and hopefully enables them to make more profits. So that's the value. When we talk about big data, we're not really talking about farm level data. That's small data, as we like to refer to it sometimes. Big data is looking at the use information across a bunch of farms, looking at patterns across regions and trying to develop value that way. So those sort of data privacy issues that are tied to that collection of data is going to be very applicable, I think, to the applications that we're going to see in agriculture. Dave Stokowski asks, is farm data needed to be addressed in a landowner's will? And as a guy that does lots of farm transition workshops, I'm going to say yes. And I say that not jokingly. A person's digital estate is starting to get a bigger and bigger impact on someone's life. We've just dealt with this in my own family because we had a family member pass away and we really needed access to that person's cell phone because we needed access to their contacts so we could get in touch with their vendors and their customers to help them know what had happened. So that's obviously a really big issue there. Oklahoma and about 9 other states do have digital estate statutes that talk about the right of a person's estate to access their digital accounts. And I think that over time you're going to see that spread, but for right now I think it's really important to address that directly in a person's estate planning documentation. Subu asks, what are the current uses of ag data when disclosed to a third party, and what are the anticipated uses in the future? There's a lot of them. And that's something you really have to pay attention to in the user agreement. And this is not an endorsement, but for example, I've read the John Deere privacy agreement and the Climate Corporation privacy agreements, and they basically specify the company will make use of this information in this way. We will not make use of it in other ways. If we do want to disclose the data to a third party, we will do so only with your consent. Okay, so not all agreements say that, and really you have to look at the agreement very carefully to see what uses can and can't be made and what kind of transfers can be made to a third party. That loops back to our previous question that we were talking about in terms of what are the damages if it is disclosed to someone and we actually don't give that sort of permission. Looking at some of the other items here. Oh, Todd's confirmed his website address. We mentioned that earlier. That's www.aglaw.us. And dang it, he got to that domain before anybody else did. So good job, Todd. That's www.aglaw.us. Let's see here. Oh, I'm sorry.
Can you hear me?
Yes.
This is Terry Griffin from Kansas State University. I just want to add a comment about primary and secondary uses of data. One of the key things to me is that when the data sector is truly mature, that's when the secondary uses of ag data will have a higher value than a summation of all the primary uses. And I think that's a key difference when it comes to big data, and something that we need to think about as we move forward. You know, how can ag data be used in the collective that will have additional value to the system?
Excellent point. Paul, how are we doing on time?
This is Ashley. We actually have 5 more minutes, so if there's any more questions, and unfortunately, I can't see any questions, so I apologize. I have not been participating in this Q&A section, but I'd be happy if once we get off, if anyone has questions via email, I can definitely go that route. But Shannon's been doing an amazing job, and thank you, Terry, for chiming in. If you see any more pop up, Shannon, just go ahead and answer them, and I'll chime in here in a few minutes to wrap up things up if we don't have anything else left.
Okay, and Ashley's going to see me in person as we're both speaking at a conference later this week, so she can beat me directly if I did too much of a hog job on taking the questions. Steve observed some emerging analytics require data from various sources, some of which are public. Other data will be collected on the farm. Can trade secret protect the unique combination of data that pertains to a single farm? Again, you guys have had absolutely outstanding questions. Good job, audience. I give you guys gold stars all the way around. It's a very good question. Trade secret data, like we talked about, could be used to protect information that has value because it hasn't been disclosed. So to the extent that information has a public information component, meaning we acquired part of this mix of information from a public source, that starts to kind of make it more difficult to protect as a trade secret. Now you could argue, hey, if you hadn't had my trade secret information coupled with your publicly available information, you wouldn't have arrived at what you got. And so that's probably your one hook to try to claim that you have some sort of protection with regard to that information, but it becomes really difficult. And by the way, we could probably talk in a wholly separate webinar about the ability by third parties to obtain information about your farm. I mean, the better imagery satellites that we get, the better aerial sensors that we get, there's not a lot about your farm that we couldn't find out just by flying over it in a perfectly legal way, by the way. So there's a lot to be settled on that frontier. That may be, I see, well, Rachel's already signed off. We have an endorsement that we should do a webinar just about that point. So, hey, there we go. Paul, line us up on that one. Lyron observed, and this is fascinating to me, that one state has basically assigned medical records to the patient, 20 assign it to the doctor, and by analogy, does that say what people think about things like financial data? For example, you don't own your credit score, even though it's comprised entirely of information about you. Someone else developed that from data sources and even secondary data sources like Terry was talking about. And so really, who has the right to information that's about you, even if it wasn't contributed by you? So, Lyron, that's an excellent point. Thanks for bringing that up. I think we have one more here. From Rachel, satellites can gather a lot of information from your operation without your explicit consent. Any restrictions on using this data legally? And as far as we can tell, Rachel, the answer is not really. For example, take a look at Google Earth. Developed almost exclusively using like Landsat imagery, and I can tell a lot about someone's operation from good old Google Earth data. Matter of fact, I can tell a lot about my own operation and what Mom and Dad were up to last year just by looking at the Google Earth information. So that information is out there. It is public domain, and really there's no privacy rights to it there. With that, that's the last least of what I've got in the question box, and we're about out of time. I want to thank everybody for tuning in. We had a tremendous audience and tremendous participation, so thank you very much for all being part of that. Paul, Ashley, anything else we need to do before we sign off?
Yep, I was just going to go ahead and remind everyone the next webinar coming up is on solar leasing, June 27th, again with our famous Dr. Shannon Farrell. So go ahead, the sign up is available for that already. And then again, a reminder to please fill out the evaluation if you have a minute under the links for the webinar. And there's a copy of the presentation there as well if you want a copy of that, and then access to the Maryland Risk Management Education blog and the Texas Ag Law blog as well if you want to check those links out. And thank you for everyone for tuning in, and thank you, Shannon, for presenting with us today.
Thank you, Ashley. It was good to be on the team with you.
Awesome. All right, well, everyone have a good day, and this recording will be available, I want to say, maybe 24 to 48 hours. Paul's our tech guy on that, so if anyone that you know did want to tune in and wasn't able to, the webinar will be available upcoming here in the next day or two. So thank you, and we will be signing off.